My name's Hayley. I'm the director of Tarr Law Proprietary Limited. We're a boutique intellectual property law firm, so it means we do anything related to IP. So things from registered IP rights or industrial property, they call it. So that's patents or designs, things that you have to register with IP Australia in Australia or other international intellectual property offices to acquire the rights. Or to the other end of the spectrum of unregistered intellectual property rights, so copyright that you acquire as of right. The second you create it, you're the owner of it, and in Australia you don't have to register it or anything. Interesting that there is a new thing called WIPO proof that you can use to submit copies of your copyright works to them, and they'll stamp it using blockchain technology so that you then have evidence that, I created this copyright work on this date, and if someone copies it later, you've got the proof that you had already created it. So we work through all stages of the IP life cycle. We deal with drafting and prosecution of applications, then through the commercialization process of drafting software license agreements, grower agreements for plant breeders' rights, and then to the end of the IP life cycle, so either assigning that intellectual property right to somebody else by itself or as part of a business sale agreement or as part of a settlement agreement if unfortunately things have gone a bit pear-shaped and you've had to hand off that IP to somebody to get them off your back. I do prefer transactional over dispute work, because that's the nicer end of the spectrum. With my clients, if we can be thorough and we can get it all done right from the outset, then you've got your best chance to avoid a dispute, although, we will send cease and desist letters and engage with barristers if need be, if it gets to that end of the spectrum. This morning before I came here, I was working for a client on a dispute matter where the client hadn't had lawyers assisting with drafting of the contract at the outset, so it really wasn't an advantageous contract in the first place, and now it's giving rise to a dispute, and all this money is spent on legal fees relating to the dispute for a contract that really wasn't even going to generate that much income for this person in the first place. So, legal fees are kind of like this horrible expense that you think, is it really necessary? I can check this over, this looks fine. But then sometimes you are better off just getting that lawyer, someone that knows, to look over that contract in the first place and spend the money at that end rather than getting involved in a dispute and having to spend the money at the other end. The thing that we can do is that we can help everybody, because every single person involved in business has some form of intellectual property. So, trademarks is the fundamental one. Tarr Law is our trademark. We have that as a registered trademark. But every single person who is in business would have a trademark associated with their business. So we're relevant to everyone. And in fact, 84% of the value of the S&P Standard 500 companies is in their intellectual property. So not only are we relevant to everyone, but this is like the crux of your business is your IP. So, we're not saving lives or, not healing the sick or anything, which I sometimes wish I was doing, but at least I'm helping people with something that is like the majority of the value of their company. So we're trying to add good to the world. So the first thing when a client comes to me is that I like to look at what their company structure is. Now, this isn't sort of IP specific, so it's not purely my area, but I find that everything hangs off your company structure, so it is very relevant. The thing about company structure is that it will morph over time. So even for me, at the start of the year when I started Tarr Law, I started it as a sole practitioner, so just registered for an ABN. There was not a huge amount of benefit to registering a company at that time. As I was going to be the director of the company, it'd be easy to pierce the corporate veil anyway, and I was going to be paying myself the majority of the income, so there was no sort of benefit to the corporate tax rate. Then I found that a lot of the work that I do comes from other law firms that ask me to consult to them. So they might have a complex IP matter and they might not have any law lawyers at that firm who are capable or have that qualification to do that, and so they outsource it to me. And when you're working as a consultant or an independent contractor, if you're doing it on an hourly rate, as lawyers do, it doesn't matter what you define yourself as. If you can define yourself as an independent contractor, but the law will capture you as an employee, and the other party will be liable to pay superannuation. So for their side, they need to be careful. And for your side, if you are engaging independent contractors and they're charging you on an hourly rate, you need to be careful, because you don't want to be in violation of those compulsory super guarantee laws. But so for that reason, I then incorporated. And then when I first incorporated, I set myself up as the sole shareholder of the corporation. But in time, as the income grows, you don't necessarily want to be distributing all income to yourself, and for tax reasons, it can be worthwhile setting up a trustee as the shareholder of as the shareholder of your corporation. So when it morphs, that's inevitable. The thing to try and do is to figure out your ultimate company structure as soon as you possibly can, because at the moment, because of COVID, they're waiving a lot of the tax laws around forming a corporate structure and transferring your business to that corporation. And so now's a good time to do it. But in the future, that if that sort of waiver no longer exists, you may find that there are taxes involved in morphing to that final company structure. So the earlier you can settle on your company structure and transfer any assets and value that you have to that structure, the better it is to avoid having to pay taxes down the track. The other thing that I find is that when I ask clients this question of, well, what's your structure? They say, oh, well, we're a corporation now and we were a partnership before. Oftentimes they didn't have an ABN for their partnerships, so they weren't actually a partnership. They were just a couple of mates that called themselves partners. But then I'll say, okay, well, where's the business sale agreement, or how are those assets transferred? And they won't have anything in writing. So in their mind, from the partnership to the corporation, it just sort of, because in their head it transferred, they thought it had transferred. But remember that the legal documentation also needs to be in place, so that what you think's happening in your head is also what is actually happening legally. So just making sure that at every stage when you transfer to or morph into a new entity, that you do have those documents that are in writing that reflect that. And that is particularly important for copyright, as we'll talk about throughout this, because copyright works can only be transferred in writing. It is also important for trademarks, and I'll talk about that later too. Okay, so here we go. Beware of the invalid transfer. This is about the trademark transfer. So there's a case between Kraft and Bega where they were disputing over this yellow lid. So Kraft owned the peanut butter business, and they purported to transfer the peanut butter business to Bega. Bega thought that as part of that transfer, they got the trademark, and it wasn't registered, but an unregistered trademark in the yellow lid. Bega thought, no, we transferred that unregistered trademark separately to ourselves so that we could continue to use that, and we just transferred to Bega the remainder of the peanut butter business. So Bega thinks it owns it and is using the yellow lid. Kraft thinks it owns it and is using the yellow lid, and they sue each other. Right, they spent nearly $1 million in fighting over this yellow lid in court. At this stage, Bega are winning, so it's gone to appeal, and they have held that an unregistered trademark is just goodwill, so it's not a separate asset that can be assigned separately to the business as a whole. And so that trademark had to be assigned to Bega as part of that business sale agreement. So Bega owns it. Now they've gone to the High Court about it. The reason I tell you that is that, when you're looking at your, morphing your business from one stage to the next, if say you had a business and then you're then creating a company, if that trademark isn't lodged by the time you want to transfer the asset, you can only transfer it to the company as part of that business sale agreement. So as part of the transfer of all of the business from the business to that company. If you don't do it properly and you lodge the trademark application in the wrong name, so say the business was using it for 20 years and now you go, well, I'm going to set up a company, and you just lodge it in the name of the company without a valid business sale agreement transferring it to that company, then the trademark has been lodged by an entity that is not actually the true owner of the trademark. That means that the trademark application is invalid and it cannot be rectified by a subsequent assignment. I mean, your lawyers might help you by trying to draft up a confirmatory deed of assignment, which says that the assignment happened before the fact, but it's only being written down after the fact. So there's some things that you can do, but if you really get stuck and there is no way of saying that you were the owner of the trademark at the time you lodged it, it's invalid. You'll have to file it all again. And if you look at, say, you might have spent a lot of money prosecuting that application for filing evidence of use, and your lawyer's done that, and then they might have lodged international applications that are based on that Australian application, and so there's been a lot of money on that. So it can be, tens of thousands of dollars, all because of these small little things that you need to get right. So you just got to be mindful and get advice just to make sure that you haven't done anything wrong. The sweetest guys, I've never charged them, they just call me up, and they tend to call me up after they've done something, and then it's like, no, but you shouldn't have done that. So just, and then we have to tell them how to fix it, and then they go away and try that. So don't do that. Try and get the advice before you do something wrong, if you can. Okay, so once you have got your corporate structure in place and you've transferred all of your assets from your business to your corporation, the next thing to kind of factor in is the relationship between the various parties in the corporation. So you want to think about the shareholder relationship and the director relationship. This one I say because it's happened a couple of times this year with clients, and I feel like because we're relatively small, if it's happening a couple of times, that this is a prevalent problem. It's that people start a company as equal, two directors and equal shareholders with somebody that they have a good relationship with. And then the relationship deteriorates because it's basically a quasi-partnership relationship. You've got to have a huge amount of trust and confidence in somebody if you have equal say in everything to them. And when that deteriorates, you're really quite stuck. I mean, unless you both voluntarily agree to wind up the company, the only options are to look at whether the company is potentially insolvent. Like if you as a director have loaned money, you call it in, and then maybe you can say, well, if they don't pay, then it's insolvent. Otherwise, you have to go to the court, 461K, for a winding up of the company on just and equitable grounds. So it's like a marriage. People often don't, my situation, you get into it without realizing necessarily how complex it is going to be when it all breaks down. And so you really want to think about, when you get into a corporate structure, what's my exit strategy? And if this goes badly, how are we going to deal with it? So like a prenup for a corporation. So have formal written agreements clarifying that, and that will be part of your shareholders agreement. Don't just use a template shareholders agreement. It won't have enough. You really need to think carefully about who's going to settle this if the two of us are in deadlock and one of us wants to get out, the other one doesn't. What are we going to do? Really think through the hard questions. The other thing that I've seen a couple of times this year is clarifying ownership of the IP by the company directors. So one of the things that's happened is that the company directors have had pre-existing IP, and they have loaned that IP through sort of dropping it into a shared Dropbox. So if you think about it, like for me, I had a raw vegan snack foods business, Aonva Organics, and then I called it Plant Matter, and I used to sell it to like Flannery's and Go Vita, and there was some like protein cafe, whatever they did. Like I had about 10 different distributors that would sell these raw vegan products, and so then now that I've started Tarr, potentially, although probably not in my case, I could have IP that I generated through my previous business that I think, oh wow, that would be relevant to me now, but it's my IP. It's not the IP of Tarr, it's mine. And so if I want to share that to Tarr, then I have to decide on what basis I'm going to do it. And I find what's happening is these directors are dropping it into the drop box because they're all mates and they want to help, and they're just giving the business what they have. But then down the track, when the relationship deteriorates, then it's like, well, actually, I was just loaning that to you, and that's not a company asset, and you can't sell my stuff and then divvy up the proceeds of it. But it becomes a matter for dispute. So you're better to have it clearly in writing. Hey, I'm providing this to you on a license basis, and the anything I put in the Dropbox can be licensed to the company for a nominal license fee of $10 a year or something. But in the event that I decide that I'm going to resign as a director or sell my shares or for any other reason, then that license immediately terminates and the company can no longer use that license or use that IP. So just making sure that that's really clear. All right. Oh, the other thing that needs to be really clear is the IP generated during the directorship. So, for example, I am both an employee and a director of Tarr, which is very bizarre because I'm drawing up my employment contract and it's signed by me and then on the other side by me. And you just think, wow, the law is so artificial and so ridiculous sometimes that you can be signing a contract with yourself. But in that situation, as an employee, it's going to be, and not, you should make sure that it is, if you've got employees, part of their employment terms that any IP that they generate in the course of their employment is assigned to the company. But directors, they're not signing an employment agreement unless they are also employees. But even if they are also employees, they're not signing that agreement in their capacity as director. So it would tend to be the case that IP generated by the director is not automatically assigned to the corporation. And so that can be a matter of dispute because it's like, if I generated that in the course of my directorship, who owns it? I do, and I might want to use it somewhere else. And then the company potentially has recourse for breach of director's duties if you are, say, acting against your director's duties by using something that you acquired, exclusive knowledge in through your position as a director. But it's more difficult than if you just have the directors sign that anything that they generate in the course of their directorship with the company is transferred to the company and owned by the company, if that's the intention of the parties. Okay, so once you've got your internal relationship set up between the directors, the shareholders, then start thinking, okay, what about between the company and external people? So wherever possible, use your agreements with external people. The reason I say that is, number one, it's easy for other people. Like, everyone's going to draft an agreement in their own favour. You will see it. You engage a lawyer, and they will go to their template agreement, and they'll have a template agreement in favour of the supplier or in favour of the the company to which the supplier is being provided. So you select an agreement depending on whether your client is the supplier or the other party. So you're always going to be tweaking an agreement in favour of your side, and then it becomes harder because if they give you an agreement, you don't know if there's anything hidden in there that your lawyer might miss, or it becomes hard because you're starting from against the eight ball. You've got to kind of try and modify back their agreement that's done in their favour. So if you can, use your own. And the other reason I say that is because of cost. I had a client who asked me to draw up all these template agreements, and then he's so nice, and he kept accepting the other side's agreements and then sending them to me for review. Well, he had spent the money on getting the templates made up, and now, because he's a pushover sort of, he's spending the money every time getting them reviewed. If he sent his to them, he doesn't have to spend money to review them. So there's a few advantages, like to push if you can. Sometimes though, you won't have the ability to, you don't have the bargaining power in the situation or something, so you've got to use their agreement. So just make sure that you do check all those agreements. And a couple of things from an IP perspective that you really want to check is like transfer of IP. So for external people, you might have, say, a developer that's writing code for you, or you might have a graphic designer that's designing your logo or something. You want to make sure that all the source code, object code, all of the copyright in that graphic design, everything is transferred to you, so you own it. Then you also want to have a moral rights clause in there. So a moral right is the right to be attributed as the author of the work. So if I did a painting and like for some miracle somebody decided that they wanted to buy it, they can buy it and they can buy the copyright in that painting from me. So that means that they can reproduce that painting. They can make prints, they can sell it, they can profit off that. But they cannot say that they painted it, because that wouldn't be the truth. So you cannot transfer that moral right or assign that moral right. I always have to be attributed as the author of it. But sometimes if you are using a logo like the Nike logo or something, some lady drew that, the Nike doesn't want to have just do it and then have, by Jenny Watts or whoever it was that designed that. So they want to be able to breach her moral right to be attributed as the author of the work when they use that work. So to get around that, what you need to make sure is that whoever assigns the IP to you, if there's any copyright in that IP, which there will be if it's software or if it's graphic design work, that you want to get them to consent to a breach of their moral rights and waive their right to sue you for that breach, so that then you own the IP and you can use it freely and you don't have to say that they were the author of it every time. The other thing you want to check is that all of the IP warranties and indemnities are in there. So one of the key ones is making sure that if they create a copyright work, source code, logo, that they are warranting that that is new, distinctive, original, that it's not going to infringe upon any third-party intellectual property rights. And the last one is limitation of liability. And this one was one that I saw recently, because a graphic designer had transferred a logo. So she'd transferred the IP, she'd waived her right to sue for a breach of moral rights. She'd warranted that she hadn't copied the logo of anybody else, but then she put in there a limitation of liability for the amount of the contract. And so say you pay, I don't know, $500 max for this girl to draw up a logo, but say if she breached that warranty and she did totally just copy it off somebody else, and so you might get sued by that third party because you've used that logo in infringing their copyright, and then they sue you and you say, okay, I'll pay you whatever you require for your damage. And then you go back to the graphic designer and say, hey, you breached your warranty, that was a copy. And she says, yeah, my bad, I did. I'll pay you $500 because that's the limitation of my liability. Meanwhile, you're out of pocket, whatever you paid the other person, the difference between that $500 and what you had to pay them. So when you get these external service providers to provide you with services, check all of those clauses and make sure that you don't get caught out by anything that might just be hidden in there that ends, you're out there at risk with no recourse.
Can I ask a question?
Yeah, sure.
Can you use the microphone? This one? Yeah. You can pick it up. Does it work? Yeah, probably not yet.
Oh, yeah, thank you. So, For example, I employ overseas developers
Mhm.
from another country, from Russia,
Mhm.
and I pay them from my pocket. I don't make agreements.
Mhm.
It's small job, for example, the logo or
Mhm.
some part of the code. So is the same laws applicable?
Yeah, it will be. How are you contracting with them? Is it via a particular website, because they may have terms and conditions that you're not specifically drafting yourself?
We are in a friendly relationship, so we connect
Okay.
directly.
Yeah.
And
Yeah.
also I have a company in Russia. So
Okay.
sometimes I pay using my company money, sometimes I
Yeah.
pay from the pocket.
Right. Yeah. So you should start using agreements. Even if you just set up a template agreement, and just be mindful who is paying, like who is entering into the agreement. And therefore, like it sounds like sometimes the agreement's between your Russian company, and then if your Australian company's using that mark, then there needs to be a license agreement, as well as that, assignment agreement with the designer, a license agreement from your Russian company to your Australian company, authorizing your Australian company to use the mark. And that tends to be beneficial sometimes too, because that license agreement may help you to distribute funds between companies that you might, find is helpful for tax implications. So if you're
Even if I am a sole trader in Russia and sole trader in Australia, so from one sole trader to another, me?
yeah, right, okay. Well, the only thing is, yes, because, well, I don't know enough about the tax, but would it be possible that if the Russian company that you're a sole trader for pays Russian taxes, or you still have to then disclose that as foreign income, and you
I
pay Australian rates?
taxes for Russian money to Russia and for
Yeah.
Australian money to Australia.
But then you would have to disclose your Russian
Yeah,
income
yeah,
here, so it
yeah.
doesn't really help you. Yeah. But if it was incorporated and it was a separate entity, there may be tax advantages to, say, having a high license fee, and therefore the Russian company generating more income than the Australian company. Was you paying for the use of that trademark, you're paying a high license fee. The Russian company is generating the income and paying Russian tax on that, which may or may not be less than the Australian tax rate. Does that make sense?
Yeah.
Or, yeah.
Understandable. Thank
Yeah.
you.
Okay. So we have got, say, all of our structures in place. And then once you know, okay, I've got the right corporate structure, and I'm good with my internal and external relationships, the IP is in the right place, when we should register the IP. It's not essential, as I said, for certain assets like trademarks. You can have an unregistered trademark, and you can sue for a breach of misleading, deceptive conduct under the Australian consumer laws, or for passing off at common law. But it's harder because you have to prove that you had a reputation in the mark. It's not instantaneous. Like, as soon as you get a trademark registration, you have national rights to that trademark, whereas to build up a reputation takes time, and it's only in the geographical location where you have that reputation. So if it's a restaurant, for example, you might just have that on the Gold Coast. You wouldn't have it Australia-wide. So there are a lot of benefits, and I feel that these are increasing because now with social media being so prevalent, a lot of the social media platforms have the option for you to lodge a takedown notice. So if somebody's infringing your copyright work or your trademark, you can just notify that platform and they'll take it down without you having to go through legal channels like sending cease and desist letters and going to court. But they'll require proof, and so you can't just say to them, oh, that's my trademark, and they'll take it down. They're going to say, well, where's your registration? And the other benefit I was saying before is that, well, it's transferable then. I can assign it to a trademark to a Russian company, or I can, an Irish company, as I've had some clients inquiring about recently, like different, you can transfer assets outside of the set company structure. And that may be relevant to, I've got it down there, the last point, if you want to transfer it to a holding company, because as the value of the IP assets tends to be so great, you maybe want to protect that IP asset so that the risk that the trading company is engaging in, because they're contracting with third parties, they might breach that contract, they might be sued on that contract, but then all of their assets will be available for, pulling into the settlement. Whereas if this holding company's got all the IP assets, then the valuable assets are protected over here and safe from any settlement that the trading company might have to grant. So that's one reason, register it so you can assign it easily. When you're registering it, just factor in your company growth. So thinking about not only goods and services that you're providing now, but goods and services that you might start providing in the next 3 years. In Australia now, a trademark isn't vulnerable to removal for non-use for 3 years from the date that it's entered into the register. So you've got that leeway there. That's not the case in every jurisdiction. Like in the US, you have to lodge regular evidence of use to show that you are currently using the mark, but here you don't have to. You just wait and to see if somebody else applies for removal. So it's not necessarily going to happen, but you are vulnerable, but you're not vulnerable for those first 3 years, so you've got some time. So factor that in at the time you lodge it. The other thing is, think about where else you might need to lodge it outside of Australia, and this is a question that some of you are kind of up to, not with trademarks but with other things. It's like, where are going to be my valuable commercial sort of centres around the world, and registering it there, and be particularly mindful of, well, where am I manufacturing it? Because you might not think that that's used, but there have been cases that have verified that manufacturing a company, even purely for export, is use of the trademark in that country. And so you wouldn't want someone to register your mark in that country and then say, okay, well, now you can't manufacture here anymore, because to find a new country where you can set up a manufacturing hub would take time and it'd be massively disruptive to your processes. The other thing is thinking about where you are offering your products for sale. So you might have on your website offer for sale in Swiss francs, and you might offer to deliver to Switzerland. Well, that probably means, especially if you've had any purchases from there, that you are trading in that country, and you could be liable for infringement if somebody else has that trademark registered there already. So you do need to really think about, like, where am I actually offering? If I'm offering worldwide, do I need to limit that, because I might be exposing myself to risks that it's not worth it to me. The good thing that you can have there is that once you register or you apply for registration in Australia, Australia is part of an international convention where you can apply in foreign jurisdictions up to 6 months after the Australian filing date, and they will give you a priority date of the Australian trademark application. So it buys you that 6 months to save up the money and figure out where you're going to be, focusing on internationally to apply in those foreign jurisdictions. All right, I think I'm near the end. Sorry, guys. I think that's the last one. Just to say, use it or lose it. So once you've got your registration, that's not the last step. You need to, I had a client recently that had sent a cease and desist letter but not really done anything more. And so this third party's infringing their mark for almost a decade. And it's not impossible, but it becomes harder to stop blatant infringement if you don't take action against it. So you get the IP right is your right to take action against third parties. It does, having the right does do a bit of policing for you in a way, because IP Australia will reject subsequent patent applications or trademark or design applications if you already have yours registered and they can see that the subsequent application is too similar. So having the right does do a bit of policing for you, but you also need to supplement that with your own and be vigilant about taking action and letting it be known that you're kind of tough on infringers. The other thing, have written license agreements and actually exercise quality and financial control. So you need to show that you haven't just allowed anyone to use the mark and therefore lost exclusive rights. You can license it to others, but you have that their use has to be subject to your control. Use the TM and the R symbols, and that's not even just once you've registered. Before you register, you can use the TM symbol, and I recommend it because in some cases it might be that your mark is a little bit descriptive, and it helps us when it gets to the lawyers to say, hey, well, they've been using it as a trademark and claiming proprietary rights in it. They've been letting the world know because they've been using that TM symbol. So it sort of just gives that enhances the evidence of use a little bit. Yeah, that's right. So TM just means it's a trademark. You're claiming it as a trademark. You cannot, though, use the R symbol until it's registered. It's an offence to use the R symbol unless it's a registered trademark. So once you get it registered, you start using the R symbol in relation to the goods and services for which you have it registered. Like I can't register Tarr Law for legal services and then use like Tarr Law R for swimwear or something, because it's not the same. Like it has to be the goods and services that you've got it registered for. But if you start using that, then that lets your clients know, hey, not only is he claiming proprietary rights in it, he's actually got registered rights. So it's just that little bit more forceful of a warning to third parties. Okay, avoid removal for non-use. Use it in the form that you've got it registered. And so, it tends to be, especially if you've registered a logo or if you've registered it in stylized font, you might, business has been going on 8 years or something, and then you might say, oh, it's time for a revamp, and you start using different font or a slightly different logo, and it turns out, well, then that's not use of the mark that I've got, and it can be vulnerable to removal for non-use. So for that reason, it's really best if you can push it to try and get the registration for a plain word mark in block letters, simple and minimal as possible, because that really gives you the broadest scope of protection to say to third parties, hey, I've got this, and it's, there's not very much there for you to point to say, well, yours is distinguishable to mine. And the plain block letters allows you to use it in any stylized font. So the simpler, the better for your trademarks. And then, just police and enforce. So if you, like I mentioned, send takedown notices, send cease and desist letters, try negotiation, mediation. I know I was one of 4 people in Queensland put on IP Australia's list of specialist mediators for IP disputes, and it was a trial run for 2 years, and they'll keep checking in, and I was just like, nobody contacted, and I was like the cheapest too, so I thought if anybody was going to do it, then they would have tried the cheapest person. But nobody is really using mediation for IP disputes. It's not mandatory in Australia yet. It's not like family law where like everyone has to, so you do. But it potentially is a valuable resource. So don't overlook it, even though it's not commonplace yet. Some foreign jurisdictions are starting to mandate mediation for IP disputes, so you'll be ahead of the game. And then court if you can't help it. The only thing to say with that, with policing and enforcing, is sorry, I think that fly just went in my mouth. So that's a good ending to my presentation. Yeah, I wouldn't mind. I really think I swallowed that. The only thing to keep in mind with policing and enforcement is, thank you, to try and be careful or wary of defamation, because sometimes you can be so cross that somebody's taken your copyright work or something. There was a case involving Sea Folly, and they, I don't think it was Sea Folly did it, it was the other party, put sort of allegations of copyright infringement and all sorts of things on her Facebook page, and then it turned out that was defamatory. So you don't want to go public if you're you're upset about what somebody else has done. Definitely take action, but take it through the proper channels. Like don't, engage in sort of social media wars, etc. Okay, so yeah, that's last slide. Just letting you know, if you do need help, by all means, reach out to me on my email address or shoot me a text. I think they've got my mobile number and everything available. So thank you.
I do. Can I ask you a
Yeah, go for it.
Okay. Now I've got my microphone here. Okay, Hayley. How about flags? Because I heard that the Aboriginal flag was trademarked by the AFL, by the Australian Football League. Something like they were using it and they kept getting issues with it, so they ended up just trademarking it. Is that
Right.
Have you heard of anything like that?
Yeah, I mean, you raise a lot of good points because, say, in New Zealand, they have a like a Maori panel that they can check whether any emblem or sign that you have applied for is a Maori traditional symbol, and they can veto it on that grounds. We don't have in Australia a Indigenous body that is sort of sitting in IP Australia and helping to monitor whether anyone's trying to misappropriate Indigenous intellectual property that they have as a traditional right. So that's maybe something that New Zealand's doing well, and Australia could look to working on in the future. Not criticizing IP Australia in any way for not having it, because I love IP Australia. I contact them all the time with questions about my clients, and I just find that they are really helpful. So I'm not putting that out as a criticism, just a comparison. The other thing to say is that, yes, there are various restrictions on flags. When I was involved in the Commonwealth Games, there are certain statutory legislation that says that you cannot register, say, for example, the Olympic signia, things like that. So there are certain things that just cannot be registered. And there is also a provision in the legislation that says you cannot register anything that is offensive or scandalous, contrary to law. So it may be the case that there are certain things like, when people try and register, I know with coronavirus, there was like, I love COVID-19 and various things that, might potentially be considered offensive to people who have lost people. And so there is something in the legislation that gives IP Australia the right to object to registrations for things like that. So I would be surprised, although I'd have to double check what that trademark is, but I'd be surprised if they successfully registered the Aboriginal flag for anything. Yeah, I'd have to have a look. Yeah.
Say hi before.
Hello.
Hi.
In regards to your agreements, if you've got a new startup and you're in a beta format, for agreements for users as the customers, but also for service providers, do you have templates for beta agreements, or do you just use straight out agreements? Because I sort of was actually looking and creating a couple myself this week, but it was too intense, I felt, to give to a beta customer, and I thought, well, this might frighten them away. It seems too, I don't know, too formal.
Yes, I can see, and that is a wrestle, I suppose, between the lawyer side of you and the commercial side of you, because the lawyer side always wants to have that 50-page agreement that ties up all the loose ends and everything, and then commercially then that's going to be clearly a bit off-putting to whoever's provided that agreement. So I can understand that. So yeah, I don't know where so you had templates that you got from somewhere? Because I was just, yourself, okay. Yeah, because I was going to give a plug to a competitor, although I'm not really a competitor of Allen's because it's a international law firm associated with Linklaters, so it's not really like, we're not on a par yet. But they have something called the Allen's A Suite. Have you gone there? So anyone can get a copy of it, and it's just I think you enter your details and they'll send you a little folder, and it's got a lot of things that would be potentially helpful to startup companies. I think there's a shareholders agreement and an standard employment contract, a few things that you might be able to start using as a base. I think the objective is then to, once you grow, or if you have questions about it, to go to them for the, the specialised help with it. But you might have a look there, see what they've got, rather than trying to draft it yourself. And I don't know, maybe providing like a cover letter that sort of explains the contract or something, but then have it in the contract that doesn't, nothing external to the contract modifies the contract or should be taken to, as a representation towards the contract, etc., so that it doesn't affect the what's actually said in the contract, but just so that they can get a little summary of what you are saying, so that they're not too overwhelmed and they can read the summary. I don't know. Yeah.
Any other questions? Hayley, before we finish, Hayley's just signed on as a service partner with the Gold Coast Innovation Hub. Can you just tell everyone what you're doing? She comes down on the last Wednesday of the month. Could you just tell everyone how they can contact you or make a booking with you, what you might be able to help them with?
Yeah, sure. Well, I just go and sit there and I do my work out of the hub. It sort of helps me to feel connected with the other business owners, etc. So I tend to be there from about 9:30 to about 10:30, only because it hasn't been the case that there have been a lot of need, people just working on their own thing. I have had telephone conversations and emails, interactions with a lot of members of the hub, and that hasn't been in that time. It's just when they reach out, and I'm happy to provide a bit of initial advice, and then if it turns out that you do actually need someone to help you with drafting a contract or registering your trademark, then at that point I would start charging you, but I can at least provide you with some initial sort of pointers to get you in the right direction.
Great, that's fantastic. Can everybody give Hayley a round of applause and thank her for being here today?
Thank you.